All right. Well, good morning, everyone. Welcome to the Judicial Proceedings Committee. This is Friday, March 5th, 2021. We have two voting lists that we have before you. Let's start off with, is it numbered? Let's start off with voting lists number 11. And we'll just go in order. So that is Senator Bailey. That's Senate Bill 15. So is that Jamie?
Thank you, Mr. Chairman. This bill requires the Secretary of State Police to mail a postcard that provides written notice of a handgun permit's impending expiration and the instructions on how to submit a renewal application online through the Maryland State Police licensing portal to a holder of a handgun permit at least 60 days before the expiration of the permit holder, if the permit holder filed a paper handgun permit application on or before October 1st, 2019. There are no amendments in the packet. That was on the...
That's on this bill.
No, that's on the training requirement bill for the HPR now.
No, this the amendment that we did two things. First one was it removed the postcard because there were some concerns about the postcard, and the second one was first was postcard. There was a second part to that, but we actually testified to that amendment at the hearing.
Gotcha. So it's going to be, let me pull that up. I apologize, Senator. I didn't see that in my Let me pull that up.
I actually have the number. 623-9261.
623-9261.
So these are an attempt, obviously the fiscal note was the only problem with this, right? It says they're going to go digital in 2 years or something like that?
So
they are.
So that was initially what it was. Now working as we testified at the hearing with the colonel of the state police, he said that they could initially, just in one day of talking to him, drop the note by $100,000. Now the reality of that is, when we talk about this bill, they have been recording the emails of people that applied for any handgun permit since 2017. They have the data. As a policeman, when you pull somebody over on the street, you can call into the gun center and you can find out exactly the date that the person application, their handgun permit expires. The fact is, they simply do not want to do this. We do this for everything else, right? We send a renewal for everything else. The state police has told us in this instance, we don't want to do it. The note that they sent, as far as the physical note, is ridiculous. I would tell you that everyone in our offices would go to work for them immediately. The fact is, there's only 27,000 handgun permits in the state of Maryland. This went into effect last year that they started notifying people. So there's 9,000 permits for this year, 9,000 permits for next year. So as far as 9,000 permits that have to be notified, and what the amendment that we proposed did was it said, being you already have the computer notification, you can either send a letter or you can send it over a computer notification. And what they said with their note is, for that physical note, it costs them $32.38 to send one notification letter. Now, I'm here to tell you that's about as ridiculous as I can imagine. For 9,000 notifications a year, they also put in the note that they need 6 positions to do this. So that works down to about 1,500 notifications per person a year. So that's about one every hour and 30 minutes that they can do. Now, mind you, they already have this information in a database. And I'd be more than happy to share with you the fact that when you apply for an application, as far as MS Form 2901, which was revised in 6 of 2017, they already have had the email information for every person that has applied for, we're going on 4 years. They have it, they have the data, they simply don't want to do it. Now, we know when we talk about how many emails and notifications that we do, it takes about, we do thousands when each one of us personally does a mailing. You do thousands. It does not take 6 people 2 years to send 18,000 mailings. Right, at a full-time job with benefits, I'll have to say that this is ridiculous, and I would hope that we would make a stand when it comes to something like this, as ridiculous as this stance that they did, overinflating this. Because the other point that I would say is, I put this same exact bill in last year, but I put it in for dealers. So they came to the hearing and they said, well, it would be very difficult for us to have the dealers. So I took all the dealers out because dealer licenses, that's their job. They should really know when that license expires. Well, do you know when they sent me the note this year compared to last year, they raised the fee for less licenses for more than $100,000 a year.
All right. I think you've made the argument very succinctly here, so I well stated. I want to give Senator Jackson and then Senator Huff, and then I've got a question for council, and then we can move on and explain the amendments that have just been sent out to everyone's laptop.
Thank you, Mr. Chairman. I'd concur with Senator Bailey in having sat on the Budget Committee for 6 years dealing with public safety and having run a law enforcement agency. I mean, I know how when agencies are asked to do something that is a little bit different than what the agency particularly wants to do. Look, I think it makes sense, and I think, and again, I mean, we all deal with how many vehicles do we have in the state of Maryland, and how often do we get information from the state of Maryland that your license is going to expire or your registration is going to expire. I think as we deal with the state agencies going forward, this is part of the challenges we're going to see, Mr. Chair. So I think move the bill or the amendment. Are we moving the amendment? Okay, thanks.
I was just going to move favorable on the bill.
Senator Bailey, you want us to entertain your amendments, though, first, right?
I would like to put the amendment on the bill, yes.
Okay, let's just review the amendment. So, council, just one thing real quick, just for full-throated analysis here. So MSP, what was the discussion like, the feedback you got from them, and then also just if you could explain the amendments, and then we'll move forward.
I might take that a little bit out of order if that's okay. So just to hit on the amendment first, what it provides is that at least 60 days before the expiration of the permit, the Secretary would provide written notice of the permit's impending expiration and instructions on how to submit a renewal handgun permit application. That would either be done by electronic mail if the holder of the permit had provided an email address to the Secretary, or by mail. So that covers the amendment. As far as what MSP had indicated in discussions with them, they had indicated, just as Senator Bailey had, that there are approximately 27,000 permit holders in the state, and that they have been migrating over to their online licensing portal, or their web-based licensing portal. But that currently in their system they have approximately 23,000 paper files for handgun permit holders. They indicated that it would probably take them around 20 to 30 minutes per file to go back and look at the files to determine whether a notice would need to be sent out. Senator Bailey indicated there is a database, but it's a legacy system that it seems like there's some migration over from that. They currently use Lotus Notes to house that information on permit holders and the information about the permits. And I guess that's not something that they're able to filter by expiration date. So they indicated that it would require them to actually go into the paper file to make sure that they're accounting for all of the permit holders. Yeah, that's the information that I got.
Okay, got it. So we got the amendments. Do you want a motion to adopt the amendments? Senator Jackson, go ahead, real quick.
I move to adopt the amendment.
Second. Is everyone okay with that? All right, great. All right. Everyone understands what's going on. Is there a motion?
Favorable.
Second.
All right. Is everyone okay? All right, great. Favorable with amendments. The bill passes as amended. All right, next we'll move on to Senate Bill 61, Senator Lamb. That is Heather.
Okay, this bill requires a changing facility suitable for changing the diaper of a child and providing personal care for an adult to be installed in a public restroom if the building or restroom is constructed on or after October 1st, 2022, or the restroom undergoes a substantial renovation, just $30,000, on or after that date. The Board of Public Works is required to adopt standards that a changing facility must meet in order to comply with the bill, and the bill requires 211 Maryland to maintain on its website a list of all the locations of changing facilities installed.
Questions, comments, concerns? So just a couple clarifying things, and this is not, so the reason the fiscal note is actually very reasonable here is because it covers renovations that range from how much? 30,000 or more. So if you're doing renovation, it's not places of public accommodation, just public buildings, right? And is it how many per facility? Is it per bathroom, or is it per?
It specifies in the bill shall be installed in at least one public restroom, or if the restrooms are divided by gender, in at least one men's public restroom and one woman's public restroom in the building.
I think Senator Lamb has done a great job kind of taking this back from what it was initially. I think he introduced this initially last year or 2 years ago. It had a huge fiscal note. I think he did a good job curtailing the there are no amendments. So you say what? Any further discussion?
Favorable.
So Senator Lee's made a motion for a favorable. It's been seconded by Senator Heddleman. Open for discussion. All right. I think we'll just do a roll call on this then.
Vice Chair Waldstreicher.
Is everyone fine?
I don't see any, so you don't need to roll this.
All right. It's fine. Everyone's fine. All right. So good. Senator Cassidy.
Just really quickly, I mean, you know, public buildings, that would be state, county, local, and everybody, right? So, I mean, a public building would be like, you get your public works department, you have the town hall, you have your public works department a mile away. That's mostly just people working at public works, but the public can stop in if they want. So when they renovate, they've got to provide a changing station for the.
So
right?
the public building, it includes a public mass transportation
I'm sorry, I
accommodation.
can't hear you. The mic.
Oh, sorry. Public building includes a public mass transportation accommodation such as a terminal or station that is supported by public funds, and an improvement of public area that is used for gathering or amusement, including a public park or recreation center. Does not include a facility that is primarily used to provide primary or secondary education. And then the actual definition of public building is a building structure or an improved area that is owned by the state or a political subdivision of the state, or constructed for lease by the state or a public subdivision of the state. And that appears on page 2, beginning on line 4, the definition of public building.
Yeah. So I fully support where the sponsor's going with this, but I don't want to saddle municipalities with stations that would be in buildings where they would never be used. I mean, you have the town hall where people meet, the public come in, but if you have the public works building where the public occasionally comes by to say, can, schedule a bulk pickup or something of garbage, that to require in those buildings seems like it would be a waste of public funds, but it's going to apply to every public structure, right? I don't see, I mean, while it says it includes those, it's broad, so it's including all public buildings.
As drafted, the bill does not have an exception for a public building which may not be generally used. Like, it's just, there isn't an exception for what you're talking about.
I'm sorry, there's what?
There is not an exception
Yeah, there's
for
no
what you're
exceptions,
talking
it's just
about.
every public building.
Yeah, so the current exceptions that are listed in the bill appear on page 3, beginning on line 15, where the building inspector can grant an exception if it's not practicable, or or it would cause a failure to comply with applicable building standards governing the right of access to individuals with disabilities.
Okay, so he does have that, so that would still be in there.
Yeah.
A changing field is not required to be installed under this intersection if a building inspector that has jurisdiction over the public determines that the installation is not practicable. Okay, that covered, I'm fine then.
Okay.
That would give them the discretion, they say, no, the public doesn't come here, there would be no reason for
It's the
that.
same language you used with the baby changing last
Okay.
year or 2 years ago, whenever that was.
Okay, I'm fine then, Mr. Chair.
All right. All right, looks like everyone, we're all good.
Thank you,
So
Council.
it passes. This is Senate Bill 114. Josh, you're up. I think, Senator Cassidy, I know we work grouped this, and you all came up with a couple of amendments. Who was in that work group? Who was on that work group? All right. So what's the report out, I guess? Does someone want to give the readout? Go ahead, Josh.
I can introduce the bill. So this bill authorizes a person to file a petition for expungement of a conviction under Section 16303 of the Transportation Article, which is driving on a canceled, suspended, refused, or revoked license under Section 10110 of the Criminal Procedure Article. I can explain the amendment if you'd like.
Yeah, because also just explain the complication that was initially identified and then how the amendment addresses.
Yeah, so the complication is that normally when you're dealing with expungement of a criminal conviction, you have kind of two streams of records that you're dealing with. You have the court records, and then you have what we generally refer to as the criminal record, which is what goes on the criminal justice information system and shows up in background checks. But when you have a conviction under the transportation article, instead of going on the criminal record, it goes on the driving record, which is maintained by the MVA. So there is currently a statute on the books, which is Transportation Article 16117.1, which requires the MVA to periodically expunge driving records. But there is an exception within that statute, which prohibits them from expunging any record which is necessary to assess subsequent offender penalties, which basically means any offense where the statute says for a first-time offense, the penalty is X, and for a second or subsequent offense, the penalty is enhanced. And because most violations of Section 16303 are subject to such a subsequent offender penalty, the MVA is currently prohibited from expunging those convictions from a driving record. So the result is that the bill as currently drafted would allow for expungement of court records, but the driving records, if the conviction is for one of the types of violations to which the subsequent offender penalty applies, those can never be expunged because they would be necessary to assess subsequent offender penalties. So what the amendment does, which is number 118770/1, is that it brings Section 16303 into the bill and amends the subsequent offender penalty so that it only applies if the subsequent conviction occurs within 3 years of the prior conviction. So this would allow the MVA to expunge the driving record if the person otherwise qualifies for the expungement under the statute. The amendment also makes a small technical correction to the language of Section 16303.
Does anyone from the work group want to report out or speak to the amendments? Senator Castley.
So I didn't see, I mean, the amendment was sort of created after the work group met. And I guess my only concern with the amendment, when I'm looking on the amendment itself on page 2 and 3, not the reprint, but I'm just concerned that whether have we changed the law then? Maybe I'm just misreading this, but have we changed the law with regard to if I go into court and I'm driving on a suspended or revoked, then currently the court could impose some jail time, but this, we're saying, no, there can never be jail time. Are we changing that?
No, we're not changing the actual penalty. We're just saying that the enhanced penalty only applies in certain circumstances, which is if you've been convicted within 3 years of having already been convicted of the offense.
Okay, I guess I was taking that from, looking at your amendments, it's page 404, it says that a person charged with violation of the subsection, it says, must appear in court, may not prepay the fine. What we took out was, so they're subject only to a fine of $500, but can they be incarcerated at all for this?
Yeah, so what you're seeing is the technical correction that I referred to. So currently, this is for violations of subsection H or I. So when I said that
Right.
most violations of 16.303 are subject to the subsequent offender penalty, this is the exception. So in current law, subsections H or I, you're already not subject to the subsequent offender penalty. And the technical error in the drafting as it exists is that it refers to a person who is convicted of a violation of subsection H or I has to appear in court. Mm-hmm. And that's a drafting error. It obviously should say that a person charged with a violation must appear in court. So that's the technical correction that's being made
Okay,
there.
so that's all you're doing is the technical, okay.
Yeah, I understand. It looks kind of strange
Yeah.
when you look at it on the reprint, but it's
Okay.
basically clarifying that when you're charged with a violation of H or I,
Okay.
you must appear in
All
court.
right, thank you.
All right, let's make a motion to adopt the amendments. Second, all right, great. Everyone's good. Further discussion on the bill? Is there a motion? Move favorable. It's been seconded. All right. Favorable with amendments. Is everyone okay? Okay, great. Passes unanimously with amended, as amended. All right, let's go down to Senate Bill. Josh, you're up again. Senate Bill 140.
This bill requires an employer of a commercial motor vehicle driver to provide a prospective employee driver with the U.S. Department of Transportation number of any entity currently owned by the employer and the website address for the Federal Motor Carrier Safety Administration's Safety and Fitness Records System. The materials must be provided upon a bona fide offer of employment. The bill only applies to an employer that is regulated by the Federal Motor Carrier Safety Administration, operates a physical place of business in Maryland, and employs more than one driver in Maryland.
Move favorable.
Second.
Motion's on the table. It's been seconded. All right, there's a question before us. Senator Carter.
Comment. I'm definitely favorable for the bill. I was moved by the testimony both last year and this year. I just mentioned at the hearing, and I still believe that while this is a great start, I think this is just a tip of the iceberg for where we could delve into this issue and make possibly stronger legislation down the road. Thank you.
No, I couldn't agree with you more. I remember that. That was vivid testimony last year. I remember that well, and I couldn't agree with you more. Senator Castley.
I would just note for the committee that Senator Peters worked with the opposition from last year and resolved concerns. So this is a compromise bill, and there's no opposition to the file as it's come out now. Thank you.
All right, so there's been a motion for favorable. It's been seconded. Is everyone okay? Excellent. Bill passes. All right. Let's do this. Senator Walsh, are you ready to go with Senate Bill 143? Sure. All right, let's Senate Bill 143. Jamie, go ahead.
Senate Bill 143 increases the threshold for civil offense, or for the civil offense of possession of marijuana from less than 10 grams to less than 1 ounce and makes conforming changes. The bill also establishes a presumption that a person in possession of less than 1 ounce of marijuana is not in violation of the prohibition on distribution or possession with intent to distribute a controlled dangerous substance with regard to marijuana in the absence of any other evidence of a violation of the prohibition. There are 2 amendments in your packet. The first amendment is 823/1. That's 823/1. And it would provide that, notwithstanding any other provision of law, the governing body of a county, city, or other jurisdiction may enact any ordinance regarding the smoking of marijuana in a public place. The second amendment in your packet is 253-321 and pertains to smoking marijuana in vehicles. Would provide that a driver of a motor vehicle may not smoke or otherwise consume marijuana in a passenger area of a motor vehicle on a highway, and that an occupant of a motor vehicle may not smoke marijuana in a passenger area of a motor vehicle on a highway.
Excellent. Thank you very much. All right, so we'll turn to the, just real quick, to the sponsor of the amendment, and then Senator Jackson.
I mean, these are very common sense amendments. These are ones that I think 90% plus of Marylanders would agree with. The first one, you can't even go to a park right now, and I know in my county, I think in most counties, you can't even go to a park and light up a cigarette. So we allow the locals, the city of Frederick, the county to say you can't smoke a cigarette in a public park. Could you imagine then showing up with your family to a park and a bunch of people there smoking marijuana in the middle of the park where your kids are playing, everything else like that? I mean, this is just simple. We allow on tobacco use the locals to have control. And this is more serious. You're talking about smoking of marijuana in public places, so we should just give the locals that control. The next one deals with, I would hope that everyone would agree, people should not be driving down the road and smoking marijuana. It's pretty simple. It just says, don't drive to your car or have a passenger driving a car and smoking marijuana. For some reason, people think the passenger part is controversial. Well, when the way you smoke marijuana, it's combustible. It makes smoke. Ingestion of that smoke is what makes people high. Therefore, if anyone in the car, the windows up, smoking marijuana, it'll have effect on everyone, including the driver. So I think these are just about as common sense as you can get. In the past, we had this amendment, the smoking in the car, on this, and we all had voted for it in I guess was it this Senate or was it last term? I think it was this term. We had different members, I know, but so I would push these amendments. I mean, these are very common sense, especially if you're going to go to an ounce and you're going to have more marijuana. There should be some common sense controls. And again, I think going in the public, these are like 90% of things. I can't imagine anybody thinks it's a good idea to have people smoking marijuana in a car, driving on the road, or people lighting up in the parks and things like that where you can't even smoke cigarettes.
I'm going to go to Senator Jackson and Senator Carter.
I would, I'd agree on the amendments. Are we going to take them both, or are we going to do individually? I'd move on the amendments. And I guess just as a side note regarding that, I think maybe the committee needs to look at in the future, the smoking of hemp, because the smell is the smell. So that's just a public editorial. But, move the amendments. I'm good.
Okay, so No, absolutely. So, look, there's been a motion. It's been seconded, but it's open for discussion. Senator Carter, and I want to go to Senator West and keep it open for debate for a little bit.
Thanks, Mr. Chair. I was going, well, because I didn't get called on first, I couldn't speak to it, but I actually agree with amendment number 1. I have no problem with local jurisdictions making those decisions. I do have a problem with amendment number 2, or the second proposed amendment, as we are looking to expand the amount of marijuana that a person can have without being criminalized. As we hang here in the balance, knowing that there's a predictive inevitability that somewhere down the road in future years, probably sooner more so than later, we're going to most likely legalize marijuana. Part of this is about ending the disparate stops for black people, especially black males that are driving cars, where marijuana has been used so often as a pretext for a stop and for a search. If we want to legislate that people cannot smoke marijuana in their cars, that's fine. I just don't think it should be tacked on as an amendment to this particular bill. I think it's a separate bill. No smoking in cars. If that's what we want, if that's what we're moving vehicles. But to do it in this way, I think it flies in the face a little bit with what the goal is, and I think it's signaling, okay, well, people can have a certain amount of marijuana without being criminalized, but if a passenger in a car, if there's any potential that there's a smell of marijuana, and what I know, and some of us know, is that when police officers stop vehicles and contend that they smell marijuana, it doesn't have to actually even be smoked. A lot of times they're not even stopping because people are smoking. They always use that they smell marijuana as a pretext for a reason to get people out of the car, search the people, whatever. I think that this amendment is just simply inappropriate for this bill. If we want to have a discussion about how do we make sure that people aren't driving vehicles and smoking marijuana, I just think that's a separate bill. I think if we want to move this bill, we don't need to make that attachment of what a passenger can and cannot do in a moving vehicle. So that's just my opinion about this.
Excellent. So I want to give Senator Jackson, is that a response to that? So let's go Senator Jackson, then we'll go back to West.
Thank you, Mr. Chair. And my contention for the Second Amendment is, there are, you can get a contact high from marijuana, and if you're in that vehicle, the driver could essentially get a contact high, which means the driver is then driving impaired. So that's my rationale on my support for the Second Amendment.
Okay, Senator West.
Thank you, Mr. Chair. I wanted to comment, I guess, on both. The first, the one about the communities where the jurisdictions having the right to prohibit marijuana in certain circumstances. I can think of 3 just off the top of my head. So some people appreciate the smell of marijuana. Other people find it off-putting and even nauseating. And so I'm thinking the Towson Town Festival in Towson. I certainly would not want people walking around smoking marijuana. I suspect a lot of people would find it highly offensive. A second, the Baltimore Symphony Orchestra does summer concerts at Oregon Ridge Park. People take folding chairs and sit there with their families. If someone's smoking marijuana, families there are going to find it really unpleasant, and they're going to complain. And they ought to have a right to complain. And finally, because the senator from Ocean City is not here, the boardwalk in Ocean City, we certainly don't want people smoking marijuana on the boardwalk and driving families away and saying this is not the kind of place we want to bring our children to any longer. So it just seems to me that's self-evident. Now, with respect to the cars, I thought we already had a law in Maryland that said you couldn't smoke marijuana in cars. Didn't we pass that as a part of the initial legislation several years ago in which we stopped marijuana as being a criminal offense? Does anybody know the answer to that? Jamie?
I think it's, off the top of my head, Senator, I think it's 5601, either 5601 or 5601.1 of the criminal law article. provides that offenses involving possession or administration of marijuana being smoked in a public place are a $500 civil offense. In talking with the state's attorneys previously, this was a while ago, but there may have been some debate a couple of years ago about whether that would cover also smoking in a motor vehicle, the public place provision of that.
I was in the House at the time. I specifically recall it being discussed actively on the floor, and maybe Senator Heddleman will recall as well. I think they came back with an amendment to the bill which made it very clear that it's illegal to smoke marijuana in a car. So is this merely, is it possible that this amendment would be redundant, or isn't it already part of the law?
So you might be thinking of, in the Health General article, there's a construction provision related to medical cannabis. It says that the subtitle may not be construed to authorize any individual to engage in and does not prevent the imposition of any civil, criminal, or other penalties for the following. And that list includes smoking marijuana or cannabis in any public place, smoking marijuana or cannabis in a motor vehicle. So that's the construction provision for that part of the Health General article that authorizes medical cannabis use.
Well, that sort of says that that particular legislation should not be construed as changing the other law with respect to it.
Right.
Where I remember it was when we passed legislation which decriminalized possession of small amounts of marijuana. And I'm almost positive that we introduced an amendment at the time that was passed as part of that bill.
Vice Chair Walser he remembers what happened.
Okay, good.
In my recollection, there was an amendment by Delegate Geraldine Valentino Smith, and it got on. And I think we have passed this amendment on the Senate side. I just don't think it's happened in the same year.
Oh,
So,
interesting.
and so just to be clear, the advocates behind the bill oppose the amendments, and I want to be open about that. But that's my recollection, that this amendment has passed both chambers in opposite years, not purposefully.
Okay, well, if that's the case, then I very much favor the amendment.
So as to the position that the amendment's not appropriate for this bill, it's entirely appropriate because this has been the biggest sticking point for a lot of folks. It's a matter of public safety, and marijuana becomes an issue of public safety primarily when it's used in conjunction with driving. That's, it has other issues that people can oppose, but it has individual issues of safety, certainly, but when it comes to public safety, it's its use on the roadway or how it impacts the use on the roadway. And to suggest that it's not relevant to this bill or not timely, I think it's inextricably interwoven with the subject matter of this bill. So I think it's absolutely necessary it goes on here. As to the possibility that a criminal sanction or a traffic sanction or any other sanction can be misused, if that's going to be a litmus test from now on in this General Assembly, we'll just stop, we'll just put a freeze on anything doing with misconduct or misdeeds or any prohibitions, because any prohibition of the law could be misused by the law enforcement, by local officials, by anybody. So, yeah, do we have to make sure that people are fair? Yes. Do we have to keep an eye out for unfair treatment? Absolutely. But to have that as a sort of a barrier that we just aren't going to be able to cross, folks, we got to move on. We got to keep on. We got to look out for the public safety. This stuff is dangerous, and traffic deaths traffic is the leading cause of death in the state of Maryland, and we've got to attend to that and not ignore that. So I just think the amendment is wholly appropriate. Thank you.
Yes, thank you, Mr. Chairman, and I have that same recollection that Senator West and probably Sidnor and Heddleman and Walstrecker have. Delegate Geraldine Valentino Smith proposed the amendment in regards to recreational marijuana and the use of it in a parked vehicle, right? Not just standing on a corner, not just on a bench. And she, I think the delegate's initial attempt was to get it for the moving vehicle, but, you know, sometimes folks are sitting in a vehicle at a park or somewhere and they're smoking, and that's where that piece came from. And again, I don't think it connected on the Senate side, but I stand by the support of the both amendments.
Just to be clear, too, I mean, everyone, this has been a standalone bill. It's come in a number of years. I'm going to suffice to say every member here has probably voted on this amendment in one way or another. I know it's passed through the Senate at least twice on this bill. And this doesn't change as far as, I mean, my understanding is that's case law as far as when you can pull people over and the smell of marijuana and all this. This doesn't do this. This specifically says may not smoke or otherwise consume. So dealing with smell or possession and searchability, my understanding is that was all basically case law in Maryland. And this doesn't change that.
We'll go to Senator Carter, but I was asking Jamie on the side. Like, I think there was a Supreme Court case that was on point here, but Senator Carter, go ahead.
Thanks. I just want to be very cautious and careful because I think we're moving in a better direction in this area, and I don't want to do something that's going to be a hindrance. I'm not sure if this is what we're referring to, but just this past summer, the Maryland Court of Appeals came up with made a ruling that the smell of marijuana in a vehicle could not be a precursor to arrest or search of an individual. It did not include, the decision didn't include a search of a vehicle. It just simply said it can't be used as a pretext or as a reason to make an arrest. My concern is if we do that, if we pass this amendment in this bill, does this somehow set that, change that decision? Like once we pass this legislation, will the Court of Appeals come back and say, well, now that the legislature has spoken and said that it's illegal to have even a passenger in a car smoke it, doesn't that kind of change? That I'm concerned it might. And that's not a direction that I want to go in. And for the record, I don't agree with smoking marijuana or being high while driving. It's not something I agree with. I actually take issue with the parked vehicle because a lot of people don't have any place else to smoke. You can't smoke in the public. Some people can't smoke in the house. They may not be driving, but in some instances, smoking in the car may be even the only place some people can smoke, even people that have the medical certification to smoke because maybe their spouse or their family doesn't like the odor or they want to keep it from them. So parked vehicle really shouldn't be a consideration. But a moving vehicle, no. I don't condone smoking in a moving vehicle. I'm just concerned that we're extending this to a passenger and not the actual driver, and there's no empirical data that every time a passenger in a vehicle is smoking, the driver gets a contact. I can tell you driving down the street, and you all know this, in recent years, there's rarely a time I get in my vehicle and I do not smell the odor of marijuana as I pass other vehicles and people on the road, but I don't believe that I'm getting a contact high from just smelling it. So I don't want to make that giant leap that any passenger that smokes in a car, we're going to believe that the driver necessarily has a contact high and should be held to account for what that passenger does. So I think this is, I have a lot of concern and caution with proceeding with this part of the amendment. If we took passenger out, I'd be more comfortable.
Thank you. And just for clarification purposes, we're solely talking about a driver or an occupant when smoking while the vehicle is on the highway. And by highway, we're talking, a street. So, I mean, you could be parked in a park or parked on your parking pad or something like that, and this amendment wouldn't affect a driver or a passenger's consumption. Am I reading that correct?
That's why it says on a highway. So you're trying to get not somebody parked somewhere. So you're exactly.
Okay. To Senator Carter's point, I'm wondering in Section E, I think her concern is somebody who's not the driver sitting in and wanting to smoke in the vehicle. The larger concern that I'm hearing is someone smoking in a vehicle that isn't the driver, but they're not I guess they're not the only one in the car. So there's a driver and an occupant. The occupant is consuming the marijuana. The driver is consuming the smoke of the marijuana. So I mean, but it's not. But your concern isn't necessarily just an occupant sitting in the car. So I'm wondering if there's a way to modify to get at what Senator Carter's concern is.
And let's face it, a lot of circumstances they could be passing a joint around, or you get pulled over and you just hand the joint over to the occupant. So I think it's just clear policy to say no smoking in a car. It reminds me of, to be honest, it reminds me of that movie Cheech and Chong in the beginning where they're all driving, there's like smoke rolling out of the windows and everything. It's like, we just say no to that. Don't smoke marijuana and drive around. We spend all this time on don't hold your cell phone and do all this stuff with your cell phone. We regulate the hell out of that. It just makes sense to say nobody smoke marijuana when you're driving. It's that's just a good rule of the road. I mean,
I'm done. Thank you.
So I know Senator Carter's concern was that this recent Court of Appeals decision that said the smell of marijuana would not justify the stop and the search because it could have been lawfully owned marijuana, and so you can't presume a crime, right? I guess that's kind of where the court was coming from. But I don't think that's inconsistent with this. I think, in fact, this supports that law because the fact that it only applies, it doesn't say you can't smoke in your car, to your point. It doesn't say you can't sit in your backyard or anywhere else and smoke in your car. And therefore, the fact that when an officer comes up and your car reeks of old marijuana smell would not in any way justify assumption that there had been a criminal activity. Now, I guess if they pulled you over on the highway and you roll down the window and there's marijuana smoke billowing out, the Cheech and Chong movie that Senator Huff described, that's not just the smell, it's the smoke rolling out the windows. But I think it's entirely consistent with what the existing law, and it really reinforces that because it's saying that we're not saying you can't smoke in an automobile that has tags on it, a licensed automobile. We're saying you can't do it on the highway, operating it on the highway. So, which to me says, well, we're not saying you can't do it when you're not operating on the highway. So you would expect that people who consume marijuana very well would lawfully sit in their car and smoke marijuana, and make their car smell like people who smoke cigarettes in their car, make it reek of tobacco or marijuana. So, thank you.
Thank you, Mr. Chairman. And just to speak to the amendment, and I think we got off a little bit because we were trying to recollect a bill or an amendment in the past that dealt with a parked vehicle. I mean, this deals with a moving vehicle. And again, my contention is this, it's a public safety issue. If I drive by a vehicle that someone is ingesting marijuana or hemp, I smell it, but then I'm moving beyond that vehicle. We're talking about occupants of the vehicle smoking, and you're in the vehicle for a period of time, and there's a possibility of the consumption by the driver, even if the driver isn't actively smoking it or ingesting it. And I just think that we need to be very careful about the risk of the driver being impaired, and that's my perspective. And
so we've got a motion for both amendments. It's been seconded. I ask respectfully, it seems to be broad consensus on the first amendment. Okay, can we do? Okay, thank you very much.
move the First Amendment.
Okay, got it. So there's prior motion has been withdrawn. There's broad consensus on the First Amendment, which is it's been seconded and everyone is okay with that. Okay, that's on there now. All right, let's come back to this later. I know. Yes, this is Senator Carter. Go ahead, but I want to.
Quick question.
Of course, absolutely. Yeah.
So with Senator Huff's amendment regarding the concern about the passenger and marijuana or the driver and marijuana, does it impose a ticket or a fine for so doing, or is it just a prohibition in the bill that you'd be making?
$500 misdemeanor.
Okay, I didn't have it in front of me, that's all.
All right, let's hold this for the second part of the discussion, because, you know, it has been an interesting discussion. We'll get some more information about what the Supreme Court says and what you said. There was a circuit court case, Jill? Oh, Court of Appeals case, okay. Great, so let's look at that Court of Appeals case, and we'll have a more informed discussion when we come back. So let's just hold it for now. We'll keep going. The bells are not ringing yet, so let's keep going. Do I hear bells? No? All right.
Yeah, you have an hour.
Oh, we're okay. Okay. I thought we were going at 11 for some reason. We've got rules at 11:30. Okay, let's keep pushing then. All right. So Senator Huff, Senate Bill 190.
Marijuana bill we can all agree with.
Who's got that? That's Jamie.
Thank you, Mr. Chairman. So Senate Bill 190 would specify that a person may not be denied the right to purchase, possess, or carry a firearm solely on the basis that the person is authorized to use medical cannabis.
Same exact bill that's passed the Senate unanimously 4 or 5 years. So.
Seconded, favorable. Is everyone okay? Additional questions? Same posture. Okay. Okay, Senate Bill 2, I'm sorry, good. Senator Lee.
Has there anybody been, was there like a lot of people that were denied firearms because of this reason that you have?
There are a lot of people that have been denied firearms because of this. Well, if you read right now under the state law, if the state police, I think they're actively enforcing it right now?
But
Probably
cases,
not. But if the
is that why
state,
you brought the bill?
well, if the state police wanted to, they could pull everyone with a marijuana card and charge them all. Any of them that have a gun now.
I agree with this. I agree with the bill. I was just wondering, was there a lot of cases where they were denied because?
No, I mean in the past when we had live hearings, we did have a good number of vets come in and
I do agree
testify
with
they were
Bill, though.
concerned, but I don't.
I'm wondering.
Yeah, I don't think they're actively enforcing it. It's one of those things. If they did, it would be a big issue, and people are scared.
Okay. Oh, that's fine. Let's roll it. I'm sorry to delay things. Let's go.
All right, Jamie, we'll go to Senate Bill 201.
Thank you, Mr. Chairman. This bill reduces from 3 years to 18 months the waiting period applicable to filing certain petitions for expungement of records under the criminal procedure article. There are 2 amendments in your packet. The first amendment is from Senator Patterson. This is Amendment 243-426/1. That's Amendment 243-426/1. It provides that for any petition for expungement, which would include a petition based on acquittal, null pros, or dismissal, as well as probation before judgment or a stat, that the petitioner would need to file a written general waiver and release of all of the petitioner's tort claims arising from the charge on a form that the court requires if the petition is filed before the expiration of the statute of limitations, which is generally 3 years.
I'm sorry, what? Why does he want to do that?
So the feedback from the judiciary and maybe some of the other stakeholders too was that currently the 3-year waiting period on filing a petition for expungement lines up with the 3-year statute of limitations. So there's a practical point where if somebody were to file a civil suit related to the charge that had been expunged, there really wouldn't be the records available to proceed with that civil suit.
bill already provides. I'm sorry, I'm missing something. I mean, the bill already provides on page 3 that you have to file a petition for a release, right? So how's it changing what's currently on the bill on page 3, lines 16 through 19?
Right. So, well, actually, with exactly in that spot with the current law, a person who's been acquitted, null prost, or had their charges dismissed can file earlier than the 3 years if they have filed with the petition a general waiver and release of all the petitioner's tort claims arising from the charge. But that only applies to the acquittal, null pros, and dismissal. If you look at lines 20 through 22, the current law related to PBJs and STETs with the requirement of drug and alcohol treatment are still, they don't have the provision allowing for an early filing if there's a waiver. And then actually on page 4, if you look at lines 4 through 7, those are findings of not criminally responsible for certain specified offenses like urination or defecation in public, panhandling, drinking an alcoholic beverage. Those also don't have the provision authorizing early filing with a waiver.
But I'm not sure, how is this addressed? I mean, the concerns were not with the null pros, acquittal, and dismissal. The concerns that were addressed were with the probation.
Right.
For based upon STET. And that was because they could leave it on the STET docket, and this would change the whole tenor of the STET docket, right?
I believe that that was mentioned at the bill hearing. The getting rid of the records that were put on the STET docket in a shorter period of time.
Thank you, Mr. Chairman. This is a really good bill idea, and the amendments begin to address the concerns that were expressed during the hearing. It sounds like there's some unreadiness, and so I think there's an important kernel here that we can pass. And so I would just ask, perhaps Senator Sidnor, I know your name is on the bill. Senator Castley, I know you have some concerns, but generally supportive of the idea. If the three of us could get together, try to work this out over the next week, I think we could get there. Would that work for you, Mr. Chairman?
All right, so Sidnor, Castley, Wallstreicher will workshop it. Excellent. All right, Senate Bill 263.
This bill makes various changes to laws governing corporate actions, including with respect to form selection requirements, remote stockholder meetings, the Maryland Control Share Acquisition Act, and premature stock issuances. The bill also makes other technical and clarifying changes.
Senator Wallstreicher or West want to explain what the bill does? No, I got it. Go ahead. Go ahead, Senator West. Go ahead.
It's the annual technical correction bill that the the State Bar Association sections on corporations and business law always produces. And this year, unlike other years, there's nothing really salient about the bill that jumps out as being important. It's all rather modest stuff. Part of it provides forum selection provisions. It says you have to include a court in Maryland. So there have been some people who thought they were being clever by having a forum selection provision in their corporate charter that says any lawsuit will be brought in Alaska or something like that. So this requires them to choose at least one court in Maryland. They can specify a particular Maryland court rather than just all the Maryland courts, so that, again, someone being clever can't file the case in Somerset County and require everybody to troop down to the circuit court in Somerset County. You'd have to file it in a more, they could choose a more convenient location where the case has to be filed. And then there are a couple of occasions where documents are passed by the corporation to increase the number of the shares of stock, for example. And the shares of stock are actually issued before they do what they should do, which is file evidence of those resolutions with the State Department of Assessments and Taxation. And this bill just says if you later on file the Articles of Amendment with the State Department of Assessments and Taxation, you retroactively ratify, as it were, the issuance of the additional shares of stock. So they're all technical things. It's a good bill. I read through the whole thing and went over with Bill Carlson, who came and testified, and it all made sense to me.
All right, we've got Senator Heddleman and then Senator Carter.
Thank you very much, Mr. Chairman. I guess, can I ask the sponsor a question? So why is it that we give corporations the ability to forum shop? I mean, I know you're reining it in here, but they could say, we never want to try a case in Baltimore City ever again, and they could have the authority to do that under this, it looks like.
Well, they have to choose a court in Maryland, but they can choose a particular court in Maryland. So they could say the U.S. District Court for the District of Maryland, where they could say the Circuit Court for Montgomery County if the corporation's down in Montgomery County and most of the stockholders are in Montgomery County.
Right.
I don't think it's an attempt to evade Baltimore City.
Mm-hmm.
These cases are rarely tried with juries anyway. They tend to be judge trials. And so there are some jurisdictions that are now, in Delaware, they have a court of chancery. And the judges in the court of chancery, that's all they do. They do business cases. That's why so many people around the country incorporate in Delaware, because they love the idea of an extremely impressive, well-trained business judge hearing their case. Mm-hmm. So it may be in Maryland that a particular county, let's say Anne Arundel County, gets a reputation as having really good business judges. And they'd want the case to be tried in Anne Arundel County. Mm-hmm. That's what's going on here.
Okay, thank you.
Senator Carter did it. All right. Favorable has been seconded. Is everyone good? Excellent. All right. Bill passes unanimously. Okay. Now we are on to Senate Bill 293. Josh, you're up.
This bill prohibits an individual from causing the serious physical injury or death of a vulnerable individual as a result of the individual operating a motor vehicle in violation of any rule of the road and the vehicle law. The violator is guilty of a misdemeanor and is subject to a maximum fine of $2,000. An individual charged with a violation must appear in court and may not prepay the fine. The court may, in addition to imposing a fine, order a violator to participate in a motor vehicle safety course and perform up to 150 hours of community service. The MVA must suspend the driver's license of an individual convicted of a violation for at least 7 days and up to 6 months. So if you recall, in a prior voting session on February 5th, the committee adopted an amendment to clarify that a pedestrian or an individual riding or leading an animal on a highway, in order for the bill to apply, they must be doing so lawfully. So just to get specific about that amendment, it would, on page 1 in line 7, insert the word lawfully after the word is, and on the same page in line 12, it would also insert the word lawfully after the word is.
Thank you, Mr. Chairman. And yes, we did adopt those amendments. And thank you for Senator West for the clarity. So in my recollection, where we left off is I think Senator Heddleman expressed concern about the mandatory minimum that's in the bill. And I know the advocates have want that in the bill. So I think Senator Heddleman's okay with the mandatory minimum. I'm okay with the bill as it came in. But I just want to give a status of where we are. I don't think we adopted any amendments related to the mandatory minimum.
I got more information and clarification after long conversations and deep digging into this, and I'm comfortable with the bill. Thank you.
The license suspension. So not in the sense of what you're thinking, like.
Was that an amendment or in the bill already?
No, it's in the bill already.
What page?
Page 3, line 13.
Oh, I'm sorry, it's the driver's license suspension, not a.
Yeah, it's not what
All
you're
right.
thinking. Yeah.
Not a, I was looking for a.
Yeah.
Okay.
All right. I know. Not in it. All right. Is everyone any further discussion? Sorry, Senator Sidner.
And this is simply a question. It's not that I'm intending of voting against the bill, but we just had that hearing yesterday about those vehicles that are going to be if passed, may be operating on our sidewalks, and I'm wondering. Oh, you know what? Never mind. I guess we'll deal with it. I'm just trying to think ahead. When that comes, how do those two bills operate in conjunction? I said, never mind.
So what was the robot's name? Does anyone remember the robot's name or the shipping? Scout.
Scout.
Yeah. We're gonna add Scout as a vulnerable.
See, well, I'm wondering if Scout hits one of these folks. That's what I'm wondering.
All right. All right, Counsel, go ahead. You.
Good answer. It would not apply because I believe in that bill it defined those as not being vehicles or motor vehicles, and this requires you to be operating a motor vehicle. So just to put that out there.
And Scout's top speed is 10 miles an hour, I think. So I think we'd be okay. Okay. Further discussion. Is there a motion?
Favorable, Mr. Chairman.
So motions were favorable. It's been seconded. Is everyone okay? Favorable with amendments from before. All right. Everyone looks to be okay. Great. All right. Now we'll move on to Senate Bill 327.
Senate Bill 327, Civil Actions, Financial Exploitations of Vulnerable Adults. This bill establishes a civil cause of action that a financially exploited vulnerable adult may bring against a financial exploiter of the vulnerable adult. The cause of action is authorized under the bill, survives the death of the vulnerable adult, and is in addition to and cumulative with any other criminal or administrative claims, legal or equitable causes of action, and other remedies available to the vulnerable adult. The bill includes additional provisions specifying individuals who may bring a cause of action on the vulnerable adult's behalf, damages and relief that may be awarded, and a statute of limitations for the cause of action. So there is an amendment in your packet proposed by the sponsor of the bill. It specifies that the bill does not apply to any act taken by certain financial institutions.
Senator Lee has a question first.
Were you able to address some of the concerns of the Consumer Protection Division of the AG's office about their cause of action on?
Yeah, so that's a good question. Let me kind of make a broader statement and address that question as part of it. So as many of you know, this process has been a year-long process between multiple section councils as part of the Bar Association. They worked through this, a lot of difficult issues, and came to a consensus. And then, as you heard from counsel, the bankers had an objection, and then the groups that were creating this bill worked with the bankers to create an amendment to solve that problem. So this has been an extremely long, thoughtful, and collaborative process. Towards the end of that process, the Attorney General's Consumer Protection Division has raised some objections, and so it's relatively late in the process. I want to be respectful of those objections and give them time to work it out. But I think we're moving it this year, and I think everyone behind the bill is ready to go on this. So I would just ask Mr. Chairman that we could hold it for 1 week so that the Attorney General's office and the bill's Bar Association advocates can work out any remaining issues. but we'll move it by crossover, please.
Got it. So just to be clear, do you want to adopt the amendment now, or just hold the whole thing?
Yeah, could we?
Yeah, let's do that. Okay, so can we, I'll make a motion to adopt the amendment that's before you, so we work off of it when we come back. Seconded, is everyone okay with that? Yes. Yes. 133521/1. Senator Sidnor.
Just for clarification, it exempts banks and those from doing what exactly?
So this bill is designed primarily to prevent individuals from taking advantage of vulnerable adults for financial purposes. And so the amendment makes clear that banks, as an institution, are not covered under the law that we're passing. But if a bank employee could certainly be held to be liable under the bill. It's that the institution is not responsible in this piece of legislation. It might be responsible outside of this bill, but is not part of this. This is designed primarily for family members and other individuals who take advantage of older adults.
I know some years ago you had the prime lending, Wells Fargo and some other banks were taking advantage of older people. That's not what this is about. They fall under some other statute. Okay, thank you.
Move on, because we said we're going to hold it, but Senator Sidnor opened up my question as well. What is the efficacy of removing the banks from potentially being liable in the bill?
Yeah, it's because that's not the primary purpose of the bill. The primary purpose of the bill is to cover family members and other folks who are close to the individual from taking advantage of that individual in a fraudulent way. And so it was never designed for this kind of institutional concern that you've expressed. What we're seeing and what the Bar Association is seeing is an increasing amount of family members who take advantage of their own relatives, sometimes their own parents, in the twilight of their life to steal money to which they are not entitled. And so I hear what you're saying about Wells Fargo. I'm familiar with the issue. I have no doubt that in California, where a lot of these cases came out, they were sued. In fact, I believe the Attorney General of California settled with Wells Fargo in some kind of historic settlement because of what Wells Fargo did. And so I think it's a real concern. I just don't think it's the subject of this bill. And the advocates behind the bill wanted to make that clear and did so with the Bankers Association.
I understand. My concern is that I'm thinking that the family member or other person most likely is using or able to do this through the use of the bank. So, like, for example, if they're forging documents or whatever, there is some responsibility or accountability that the bank should have for not catching forged documents or other kinds of fraudulent schemes, and I would not want to let them off of the hook for their responsibility on those, saying, hey, they can't possibly be liable, because after all, this is still civil, not criminal. That's a little concern I have, but we can talk about it before the vote next week.
Okay, and just to be clear, the amendment does not immunize the banks from liability. It simply does not include them in the bill. And so to the extent that they are already obligated, for due diligence, for know your customer, that would continue to be the case. It doesn't provide any level of immunity.
All right, excellent. So there's an amendment. It's been seconded to adopt the amendments. Is everyone okay with that? That's still open? All right, great. So the bill will be held until next voting session. We'll come work off the amended bill. All right, now we'll go on to Jamie, Senate Bill 385.
Thank you, Mr. Chairman. Senate Bill 385 alters the provisions of state law relating to theft, provides that the theft scheme and continuing course of conduct provisions of the law relating to valuation in theft cases include provides that multiple thefts committed by the same person in multiple counties under one scheme or continuing course of conduct may be aggregated and prosecuted in any county in which one of the thefts occurred. It also provides or increases the threshold for warrantless arrest in cases involving theft, and requires that if a court finds that a defendant committed organized retail theft, the finding must be included in the court record and reported to the Criminal Justice Information System Central Repository.
So you bump it up by $500. All right, good.
So this one really just, you notice that it does not include stealing for your own personal use. These are specifically going after those folks. We passed this one last year, but the bill specifically targeting these organized gangs who, for example, last year we had one that came out of like New York and came through, was just heading all the way down 95 through Maryland, and they would pull off. They had a couple of cars. They would pull off. They were very organized, very professional. They would go hit the malls right along 95, go in, grab expensive stuff, and then book. They had getaway cars so the person can walk towards the door and then jump in the car and flee. So this wasn't people stealing because they were going to use it. This is stealing in an organized fashion so you could pocket lots of money or return the stuff and reclaim profits and the like. So it's not your ordinary theft. It's particularly egregious. It's very effective, so that's why the intent is to allow them then to say, you didn't just steal something here and that's in isolation. It lets you say, well, it lets you bring together all those charges for the entire trip down 95, hitting all these various malls, prosecuted all as one big scheme. Thank you.
Thank you. Senator Cassidy, I did think I remembered that did we not pass this last year? We just didn't make it through the House?
It was like an amendment either on the House side, and then it didn't connect before.
So I do have a question because I don't remember this part of it. I do think I supported it last year. What's the warrantless arrest edition? What's that for?
Oh, to allow them. I mean, these may be thefts under $500, so it's because you have. I mean, you're trying to catch people who are going through the state, and that officer only has evidence that you're taking a small amount. You could pick those people up before they leave the state. It's my understanding.
No, I was just going to say that it is increasing the threshold for by $500. There's also additional language in there. 7105 is being bracketed out. That looks to be a technical correction because 7105 is motor vehicle theft, but that's a felony, so wouldn't need to be included on that list. And then the reference to 7104G4 relates to a person who has 4 or more prior convictions under the subtitle and who's convicted of theft of property or services with a value less than $1,500, but that's still subsumed under 7104.
I got a quick question. Jamie, what section deals with the warrantless search? I didn't see it. Is it an amendment? Is it an amendment?
Well, I'm sorry, Senator, did you say warrantless arrest?
Or was it a warrantless search or an arrest?
Warrantless arrest, Senator.
What section is that?
That is section 2-203 of the criminal procedure article.
Is it in this bill, though?
It is. It's on page 2, starting at line 15.
Okay, let me just look. Okay. was everything in this bill and the bill that we passed before last year, Senator Castley?
It's the same bill.
So it's exact same? It's
Same
got
bill,
everything
yes.
in there? Okay, all right, thank you.
Further discussion? All right, is there a motion? Favorable, Senate has been seconded. Is everyone okay? All right, passes. All right, Senate Bill, so that passes favorably. Senate Bill 501.
This bill requires signage with specified towing information to be placed at every entrance to the parking lot of a regional mall. The bill defines regional mall as a shopping mall with at least 400,000 square feet of gross leasable areas and 2 anchor stores, with the square footage of the anchor stores excluded from the gross leasable area. The owner or operator of a parking lot may not have a vehicle towed unless the signage placement requirement of the bill is met, in addition to existing signage requirements. So you have one amendment in your packet, that is number 273022/1. Under the amendment, the signs would only be required to be placed at entrances from public roadways.
So, so Westfield asked me to put in the amendment, but I think they have spoken to the sponsor and prefer the bill move clean without the amendment. So I would not move the amendment, which I believe is mine.
Who am I asking? I guess Jamie or whoever's. I mean, if it's only from public roadways, so if I have a mall, I mean, some malls are really big, and you come into the mall complex, like way back there, and now you're driving around, and now you've been on private roadways for a while, and now you get to the parking lot, but the sign was back by Route whatever 23 when I really wasn't even looking for a parking space. And now I've driven for another mile on the private, right? That's what that would, so it would say you put it back by the highway, but not by the parking lot.
That's correct.
Okay. Right, so, it's a no amendment, okay.
So just clean bill then. All right, is there a motion? It's been second. All right, everyone good? Wait. All right, this next one, do you all remember this hearing at all? I'm going to hold it just because I've been working with the kind of, there were some people that had amendments that they offered. I've been working with them. I had a Zoom call yesterday, right? Was that yesterday? I think we're close on some language. And then Senator Castley, I know you had some concerns about things like construction sites and things. I think I've drafted up something that may assuage your concerns. I'll send it to you. And we're learning from what Illinois did. I think they took a tempered approach, which makes sense to me. So I'll have the language worked out before I bring it back. So I'm just going to ask for a hold. So we'll hold Senate Bill 504 until next week, early. Then we'll move on to, I know Senator Huff, you get the Rules Committee. Let's go to Senate Bill 643, and that is Josh.
This bill modifies the definition of absconding to include leaving a treatment facility that an individual was placed in pursuant to Section 8507 of the Health General article for drug or alcohol treatment without the permission of the administrator. You have an amendment in your packet that is number 983124/1. So this broadens the bill to apply to someone who is placed in a facility pursuant to any court order rather than just Section 8507, and I believe this was suggested by the judiciary in their testimony.
Judiciary, what it does is, so actually this was my little baby for years, the technical amendments we drafted up. That was my section of the, technical amendments. Technical violations, that was my portion of the Justice Reinvestment Act. And so what it says is that if you get a technical, you're not exposed to revocation. And we held off on touching that for years and years, but this is a persistent problem. In fact, I was the one that held off on it, but it's been a persistent problem in that it's a huge loophole now without it. The judiciary has come to us year after year saying, hey, look, we're putting people in 8507 beds. They're just taken off. And we'll say, we're going to give you the 15 days. And they're like, I don't care. I'll do the 15 days. They do the 15 days and they walk out. So the whole idea of these treatment programs and drug courts is you're holding a sentence over people's head to get them through treatment. And we've eviscerated it unless we close this loophole.
Thank you, Mr. Chairman. So the amendment, though, this broadens it, it seems, a lot. Could you explain what other circumstances then would be covered under absconding besides drug treatment?
So it's court order, and I don't know, this is what the judiciary, I guess there's other private programs or something they put people into, or drug courts. This is what the judiciary offered up, as they felt the bill wasn't inclusive enough, because it was the state's attorneys and the, obviously, state's attorneys and judiciary that want this, but the judiciary wanted that amended language because it's, my understanding is it is more encompassing, but for private facilities and drug courts.
Yeah, I believe Chief Judge Morrissey's testimony was that drug courts often use sort of alternative types of programs that don't necessarily fall under 8507. So he suggested broadening it.
So, but is it related to drug treatment? Or not necessarily?
I don't know how I actually have it on here.
Because it doesn't,
It's just one word.
Right, so it's anybody who's ordered to,
The bill currently does say that they're placed in for drug or alcohol treatment.
Yeah, so it's for a treatment. I don't know what other,
She's looking for examples other than the 8507.
yeah, but it
the beds.
strikes,
Yeah.
it strikes 8507 and just says court order. So that seems to like open up the world, and I'm wondering what the world is open to by that amendment.
Thank you, Senator Hardeman. Actually, I think you're making a really good point, and so that's a question I have as well. Because people that are assigned under the drug court programs, for example, it's anticipated that they are going to have a series of treatments that they're going to relapse over the period of time at some time, but they're not going to be having their sentence, the drug court taken away and the sentence imposed. So by opening up beyond the 8507, could this affect the drug court people?
well, with all due respect, that was always the purpose of drug court, is that the sentence hangs over your head, the complete sentence hangs over your head, and the judge has discretion of what to do with it. But that has always been the way that drug courts have worked.
No,
I don't
I'm
actually
not
know.
saying it does.
I don't actually know that this affects drug courts as much as when they send them to I was thought it was a private facility or something else. That 8507 doesn't catch all of them for these.
That's still in the bill with the amendment?
So I'm not aware of all of the I could look into it further and reach out to judiciary on exactly what programs the drug court uses. So just, even with the amendment, I'll just point out that it still does say that the court order is for drug or alcohol treatment. So it doesn't strike that language. It just strikes it specifically if it's 8507.
Can you ask a quick question? So is that because, I mean, I haven't read 8507, but I imagine it lists the various facilities that are available or the types of facilities?
Sorry, I didn't catch that, Senator.
I'm sorry.
I didn't hear you very well.
Yeah,
Sorry.
we're striking 8507. I imagine that lists and describes the specific facilities that can be used?
Section 8507. I don't think it lists specifically, but it does list,
Let's do this. Let's just, I'm gonna, Senator Huff, I'm gonna just hold this for 1 week just to get the clarity on exactly what the amendment covers, and we'll come back. We're gonna vote on Tuesday probably, so we'll have a lot of these back on Tuesday, right? Okay, let's go to Senate Bill 613.
Senate Bill 613, there's no amendments in your packet. This local bill increases the salary of the Carroll County Sheriff as follows. Beginning December 6th of 2022, the salary is increased from $110,000 to $125,000, and beginning December 5th, 2023, the salary is increased to $140,000. Due to constitutional requirements, the salary increase takes effect at the beginning of the next term of office, and there is a delegation letter of support.
Senator Jackson.
Move favorable.
Rule second, everyone knows what it does, right? Pretty straightforward. All right. All right, great. Passes unanimously. All right, we're going to skip down to Senate Bill 834, and then we will close with 669 and 670.
So there are two amendments in your packet for this bill. So this bill alters the statutory definition of harassment relating to employment discrimination. The bill explicitly includes sexual harassment within the definition of harassment and expands the definition of harassment to include conduct with certain or under certain circumstances as specified, whether or not the conduct would be considered sufficiently severe or pervasive under the precedent applied to harassment claims. The bill also alters the definition of sexual harassment and statutory provisions relating to the requirement that each state employee, as specified, completes mandatory sexual harassment prevention training. So do you want to go over the
You can read both of them, and then we'll talk about it. So there's only one letter of, well, there are 3 letters of favorable with amendments, 1 letter of concern. We now have, we had a Zoom call yesterday, the day before, for the Maryland Commission on Civil Rights. They have now submitted another letter, which I'm not sure if it's in the amendment packet, but you can attest to the fact that you received it, and you can just broadly outline that they're fine with the bill. Now they're supportive of the bill. But let's read the second amendment, and then we can walk through exactly what they mean.
Yeah, so the first amendment that I'm talking about is the Senate, or the amendment 968270. This is the one that everybody agrees on. So the first thing it does is that it strikes the language, the whether or not the conduct would be considered sufficiently severe or pervasive, because they was concerned about what that standard meant, and they thought a much clearer language would just be to say, which need not be severe or pervasive. Additionally, it also strikes the oral or written and replaces that language with verbal, nonverbal, because they thought that was a more expansive description. It would catch all the conduct that they're trying to cover. Also, if you look under the definition of harassment, so on page 2, line 24, it alters number 3. So it will read, based on the totality of the circumstances, the conduct unreasonably alters an individual's terms, conditions, or privileges of employment, including creating a working environment that is reasonably perceived by the victim to be abusive or hostile. And it strikes Roman 3 because that was creating a new standard that they thought would cause additional confusion. It makes the similar changes to the definition of sexual harassment. Yes, so those are the changes. Yes, all
they
the
all work together
advocates
on
and
this,
the
right?
commission are in favor of these amendments.
Okay.
Can you just, since we don't have it before us, can you just tell us what their letter says, the Maryland Commission on Civil Rights? Just briefly, I mean, you have to read the whole thing, but just want to make sure it's in there for the record.
Can I be put on the bill?
Senator Lee, go ahead.
Can I be a sponsor?
Absolutely, yeah. We got Senator Sidnor, go ahead.
Since I wasn't in on those discussions, I'm just curious when we're talking about nonverbal conduct. I mean, what were the examples? I mean, what are we talking about?
That came from the advocates. They were concerned that they thought oral or written limited it specifically to something that was oral or written. However, they thought verbal or nonverbal, just like more of like a presence. They just thought that there have been cases that they have worked on where it wasn't specifically verbal or nonverbal, and so it just kind of
So
fell
Charles,
out.
I'm not going to read them out again. But if you look in your bill file for MCAS's testimony and the National Women's Law Center or the Maryland Women's Law Center, they have a ton of just kind of snippets from cases that will exemplify exactly what they're talking about.
Okay.
Because I'm not going to read the.
No, that's all.
Yeah,
Okay,
it just, yeah.
thank you.
Senator Hiddleman. Senator Catholic.
So maybe, I mean, I'm just, looking at all this work. So what are we changing in summary between what the current law is and what this is doing? What are we changing then? What's the new standard?
Yeah, so currently, harassment is not defined
I can't
in the
hear
code
you.
at all, so
So
it's
it's-
case law.
Yes.
The big sticking point that they had was the severe pervasive standard, which was discussed in some of the written testimony the chair just referenced about conduct where the average person may think like, oh, like that should be considered sexual harassment or harassment, but because it's not severe or pervasive as described by the court case law, it wasn't covered. So they want to take that standard out.
So, like, just real quick, like, since it's a judicially defined, like, the judicial construct, and I think it only appears twice in our code. One was for the training manual, and there's one other. Where's the other definition? Anyway, it appears twice. If you look again at the vignettes that she's talking about, it's like this. It's got to be continuous conduct, repeated. I mean, there's some really egregious examples there. Whereas you're really trying to target, it's like, look, if it happens once, and it's like clearly sexual harassment, then it doesn't have to be severe and pervasive. Which is a judicial, I don't know, it's been, the construct, the definition has been interpreted to mean something that's what I think anyone here would think was pretty egregious. And if you look at the examples that they pulled, it's pretty incredible.
So I'm just trying to, this isn't like an area of law that I do, so I'm just trying to understand real quick that, I mean, the potential sanctions for violating these provisions would include, I guess this tees into a civil remedy. What's the, under this section of the state government article, your employer's found guilty of this or to have violated this,
Penalties? Yeah. Sure.
does that lead into a civil lawsuit then, or through EOC, or?
It can be MCCR or EEOC. The EEO, you do
Okay.
either or.
Right, and this would hold both the perpetrator as well as the employer could be liable under this, right?
Yeah.
So, does it, under the old standard, by making it have to be more pervasive, the employer could avoid liability for a single act by an employee, but now we'd say, no, your employee did something, so you're liable too? Is that where we're going with this? I'm just trying to put the bigger, in the bigger context. I mean, I'm totally against sexual harassment and all that, and so I'm not opposed to that part of this, but I do want to appreciate the fuller scheme about how does this impact, exactly what is this shift we're making here?
I'm not sure if the complaints filed against the individual was like the employee, the employer is not going to be on the hook.
If they knew or should have known.
Yeah, I mean, but if they take it, they're not employees. I like that.
Language, was it modeled from some specific place?
No, I mean, there are a couple of states that have moved forward with similar measures, but this was worked with Women's Law Center, the National Law Center, the state, MCASA, an employment law attorney, and the Maryland Commission of Civil Rights. Senator Jackson.
Yes, Mr. Chairman, thank you. I'm going to follow up a little bit on, I guess, for further clarification on what Senator Sidnor brought up, and I guess Senator Castley as well. So we're talking about moving to, I'm trying to find it, the to include nonverbal acts. Is that act or acts? So we're talking about multiple.
It could be one or multiple, but right now, again, like I'm not going to read these cases, but right now it's just the way it's been interpreted. It's just it's like kind of an obscene, continuing course of conduct, which is, I think, anyone here would be maddened by.
I mean, I understand a continuing course of conduct. I was looking at a couple of the committee testimonies from MCAS and a couple of others. I guess my only concern, I'm just looking for the clarification on whether, I certainly don't condone it either, but continuing course of conduct, absolutely. One-time occasion, I'm looking for the specifics. I guess I need to.
Okay, so, yeah. Well, the specifics I definitely say read, but then counsel, you help clarify.
Okay,
so if you're on page 2 of 4. So the new language, verbal, nonverbal, physical conduct, which need not be, which is new language, severe or pervasive, and so you go all the way down to 18. Submission to the conduct is made either explicitly or implicitly a term of condition of employment of an individual. Submission to or rejection of the conduct is used as a basis for employment decisions affecting the individual, or based on the totality of the circumstances, the conduct unreasonably alters an individual's terms, conditions, or privileges of employment. So it's a plus. It's an and. So that one thing that they do does all of this as well. It has to have that effect. Senator Carter.
I'm sorry, so your amendments, do they address the concern from the Maryland Commission on Human, you said that?
So they were part of the work group, and they all agree. And council can read from their letter in a second, if you like.
I think I got it, because that actually had the same concern where you use the term reasonable victim of discrimination. That's out.
That's struck out. And then do you want to read the statute, the portion on employer liability for Senator Castley?
Yeah, so this goes back to Senator Castley's question. So it's section 20-611 of the state government article. So in an action alleging a violation of this subtitle, which is employment discrimination, based on harassment, an employer is liable, 1, for the acts or omissions towards an employee or applicant for employment committed by an individual who 1, undertakes or recommends tangible employment actions affecting the employee or an applicant for employment, including firing, hiring, promoting, demoting, and reassigning the employee or applicant for employment, or directs, supervises, or evaluates the work activities of the employee, or 2, if the negligence of the employer led to the harassment or continuation of harassment.
On page 3, are we taking out lines 15 through 17?
15 through...
On page 3?
Yes, so that was taken out.
So then you could bring a claim, and the sole basis would be something that a reasonable person would consider as petty, slight, trivial inconvenience, or minor annoyance.
Put that out.
No, this is as, well, by taking that out, then we're saying that you could bring a claim that's based solely upon an action that reasonable person would be considered to be basically petty, slight, trivial inconvenience, or a minor annoyance. Right?
I thought it was opposite.
Well, that's saying that it would not include.
Yeah. So that the language that you're referring to is taken out both of the harassment definition and the sexual harassment definition. That was partly taken out because they believed they created a different standard about the reasonable victim of discrimination. It's not a defined term statutorily or in case law. It would be a new term.
What? So
it was, they tried to change, so page 2, lines 24 through 27, those are the changes that they tried to incorporate. So it's based on the totality of the circumstances. So the conduct must unreasonably alter the individual's terms, conditions, privileges of employment, including creating a work working environment that is reasonably perceived by the victim, and they thought the reasonably perceived by the victim is what creates an objective standard.
So it plays right into the eggshell plaintiff. If the victim is an eggshell plaintiff whose mind may not be quite right, but as long as they perceived it.
At least the advocate's argument for including reasonably there is to make it clear that this is an objective standard, so it just can't be perceived by the victim, it must be reasonably perceived by the victim.
We're creating that is perceived by the victim.
Reasonably.
So if the victim gets on the stand and says, "This is how I perceived it," then
Reasonably perceived by the victim.
oh, they're inserting reasonably.
Yeah, so you have to look at the amendment.
No, I don't have the amendment. I'm sorry.
Okay, sorry. If you go, look, it's line 26. Here, I'll give it to you.
I don't know what happened. I didn't get it in my file. My office fucked up.
Line 27.
That, it's objective and substantive. Yeah. So there, that was the rationale for them including reasonably.
Folks are still voting on other committees, so we're okay for a couple minutes here. And then Senator Hedelman, go ahead while we're waiting for
Well,
Senator
I was
Kessler.
just going to say, for examples of nonverbal things that, look at the National Women's Law Center testimony, and it delineates pretty clear examples of what the chairman was talking about.
Yeah, I'm not going to say, yeah, I don't want to read them all, but yeah. Yeah. Good, Senator Kessler.
With the amendment, we've got it's I'm sorry. The conduct is okay. So it's based on one of these immutable characteristics, and then it's either one of the three. Submission is made explicitly or a term of employment. But it may not be offensive. It may be not. It just says conduct. It's either explicitly or explicitly made. So we have conduct. There's conduct based upon an immutable characteristic. It may not be offensive in any way. But if it's a condition of employment, then it's per se harassment, or it affects the individual. For rejecting the individual, it's per se. And then number three, or based on totality of circumstances. So the standard of number three doesn't apply to 1 or 2. We're saying.
Doesn't it all apply to under K? Unwelcome sexual advances.
That's sexual, but no, there's two. There's harassment, and then there's sexual harassment is a specific form of harassment. But harassment under H doesn't have to be sexual harassment. It could be harassment based upon is any immutable characteristic. Now you're getting harassment, but there's no quantifier. Harassment could be the most petty of slights. Based upon 1 and 2, it's only 3 where we have this heightened standard that it's creating an environment that's reasonably perceived by the victim to be abusive or hostile. But in the 1 and 2 don't require it to be abusive or hostile, do they?
Is made either explicitly or implicitly.
You got to put your
during
microphone over
traditional
because I just can't hear anything you're saying.
Sorry.
Thank you.
So yes, so you're correct. So page 2, line 19 and line 22, so that's 1 and 2. So the conduct based on race, sorry, let me start over. So to simplify the definition, so harassment includes verbal, nonverbal, or physical conduct, which need not be severe or pervasive when the conduct is based on race, and submission to the conduct is made either explicitly or implicitly a term or condition of employment of an individual. You could put period there, and if the individual could prove all of that, that would constitute harassment. You wouldn't have to get to 2 or 3 because
It's just any
the conjunction
conduct that's
or.
based upon sex or age or marital status, gender identity, any conduct towards somebody, and submission to the conduct is a condition of employment, whether it's offensive or harmful, then, okay, that gives and then, or a basis for affecting employment decisions. So you, is that,
Yes, so the harassment would need to be either or.
it doesn't, but it really doesn't have to rise to harassment. It's just conduct. It's any work condition that you could say, well, you treated one sex or one gender or one age or one anything different than another. That's per se harassment. We're calling that harassment, and then,
But it's not comparative conduct, right? That's what you
it's
just
any
said.
conduct
It's
based
not
upon.
you're
The
saying
old
one
definition
worse
is
than
just
another. It's
harassment
not-
It
includes
doesn't even have to
conduct
comparative.
based
You're
on
right.
race.
It's any distinctions. I mean, you're right, Senator. Any distinction made based on any immutable characteristics, we're going to call it harassment. I mean, seems like you're denigrating the whole concept of harassment. I mean, you can already have a separate set of claims based upon that we wouldn't call harassment, right? That's based upon, unfair treatment in between the sexes or something, and not giving. Why are we calling that conduct harassment? Isn't there already a law that says, I can't say, well, all the women have to be secretaries and all the men have to be janitors? I can't have a law like that. I mean, but that's not, we don't call it harassment. It's something else under the law, and we're taking that and moving it under harassment. Why are we taking those kind of claims and characterizing them as harassment? That's what I'm not understanding. Right? Because
I don't have the
harassment
answer for
typically
you.
is something that causes people to feel harassed. But this is saying that any distinction, so again, any distinction in the workplace based upon sex, and I'm not defending those, but why are we calling them harassment? Don't we still have another piece of the law that says you can't discriminate? I mean, those are just basic discrimination claims, right? They're not based upon harassment. They're just discrimination. You can't give me one job because I'm a man and another because I'm a woman. You got to open all the jobs up to everybody, and that's just your basic discrimination complaint. But I'm just wondering why we're characterizing that as harassment now. I mean, the part that's harassment, I don't have a problem with it. That your people feel harassed. That you're treating me in a manner that I would feel harassed. I'm belittled. All right.
So if council can do this, like, you could make sure you have the All right, let's do this real quick then. This will take a second. Voting list number 10. Do a consent kill. All unfavorable. 5 of them are withdrawals. Is everyone okay? Senator Jackson?
Yes, unfavorable. I'm fine with those. Thank you.
Is everyone okay? All right, great. All right, see you guys on the floor. Well, actually, hold on. Let me see. What time we go to the floor? So here, we'll come back. What floor is? We don't have anything controversial on the floor right now, do we?
Well, I think finance you have been voting.
All right, we're good. We're probably going to vote for like. I don't think it's going to take longer than an hour when we come back, and then you'll be done by. I'm not going to say anything because then it'll get jinxed. All right, we'll be able to cut out relatively early on a Friday.